Vidhi, I believe you can begin.
Okay, Yash, thank you. Good evening to everyone present here. Students for the Promotion of International Law welcomes all the participants and the respected judges to the finals round of 12th International Law Summit, Government Law College Mumbai, Judgment Deliberation Competition 2022. Before proceeding to the final rounds, I would like to take a moment and introduce our respected judges for the final rounds. The first judge for our final round of the Judgment Deliberation Competition 2022 is Professor Dev Mita Mondal. Ms. Mondal has been gracious enough to draft the module for this year's Judgment Deliberation Competition. She completed a graduation in law from KIIT Law School, Bhubaneswar, pursuant to which she also finished her LLM with the honors in intellectual property law from Nalsar University of Law, Hyderabad. Currently, Ms. Mondal is an assistant professor of law at Hidayatullah National Law University, Raipur. Our second judge for the finals is Ms. Priyanka Khimani. Ms. Khimani is the founder of Khimani and Associates, a full-service law firm that is highly recognized for its entertainment and intellectual property practice. Regarded as one of India's young and thought-provoking lawyers, she has risen to build one of the most coveted new age firms in a short span of time. Ms. Khimani her celebrity clientele includes a distinguished lineup of award-winning songwriters, music producers, singers, film directors, actors, authors, and screenwriters. Ms. Khimani also represents and acts for leading film and digital production houses, independent record labels, and publishers, digital and technology platforms, amongst others. Additionally, Ms. Khimani is an alumni of Government Law College Mumbai, and we are proud to have her support her alma mater. Our third judge today will be none other than our beloved mentor, Professor Kishu Daswani. Professor Daswani has been teaching law at Government Law College Mumbai for over 25 years. Moreover, he's a teacher at the Masters in Public Policy Program, Human Rights and Business Law at the St. Xavier's College Mumbai. In the past, he has taught at the University of Navarra in Pamplona, Spain, and has conducted lectures at the Maharashtra Judicial Academy, Uttan, Mumbai, and Deakin University, Melbourne, Australia. He also teaches international humanitarian law at the Rotary Peace Center at Chulalongkorn University, Bangkok, Thailand. Professor Daswani is a Global Peace Index ambassador. He has conducted several workshops with national and international participants on peace and conflict resolution. Proceeding to the final rounds, I would like to mention a few rules to the participants. Participants, please take note that the following would be the order of the participants to present their oral submissions. First participant to speak will be team 26, following second participant team 25, and I'm so sorry to misrepresent. First participant will be team 25, following second participant team 26, and third participant team 28. Following communications, oral rounds shall strictly limited to the following order. We would like everyone to be mindful of the chat box to keep note of the time during the rounds. Participants are asked to maintain discipline of rules and the procedures. The discretion of time will be based on the extension of time will be based on the discretion of the judges. And in case if the participants face any network issues during the rounds, we will be taking it into the consideration while keeping a track of the time and accommodate for the same. I would be happy to answer if there are any queries now. I assume that there are no questions. Thank you, Ms. Khimani. If there are no questions, I would like to request the judges and the participants to begin with the final rounds of Judgment Deliberation Competition 2022. Thank you.
Respected marking judges, do I have the permission to commence?
Yes, please, sir.
A very good afternoon to everyone present here. I am the participating judge representing Team 25 in the instant case of Kanak Web Services versus Koshish Web Services and others. Commencing with today's deliberation, I wish to apprise everyone here that 7 issues were raised in this case. And after hearing both the counsels on merit, the court is here to announce the judgment for the day. The first issue deals with the validity of the jurisdiction of this court, where only a web-based presence of the parties is proved. Now, the traditional physical market has changed drastically because commercial contracts are being condensed in the digital space itself. Therefore, in my opinion, laws related to jurisdiction must also change, and courts should have jurisdiction on the basis of the web presence of the parties. Section 20 of the CPC states that a court would have jurisdiction when either the defendant resides, carries out business, or if the cause of action has arisen within the territorial limits of the court. In the present case, the plaintiff does not carry any commercial activity in Edkal, nor does it have any registered office here. However, following the judgment given in World Wrestling Entertainment versus Resma Collections, I find that the website of the defendant is not an offer, but it is rather an invitation to offer. So when the transaction is confirmed and the payment is concluded by the user, the entire contract is also concluded. Therefore, the defendants carry business in Dildar if a user in Dildar has seeks its services. As per Impresario Entertainment and Hospitality, mere accessibility of the defendant's website in the forum state would not be enough, and 3 additional tests have to be fulfilled. The first test is that the defendant's online activity should be one to conclude a commercial transaction. And in this case, the defendants provide cloud-based services and they take monetary consideration in return from the users. The second test is that the website should be active in nature. So the service that is provided by the defendant is based on cloud computing. The entire process from the offer to acceptance to the very mode in which service is being made to the customer, everything is completed in the digital space through the website. Thus, it can be considered active. The third test is as per banyan tree holding case, that of purposeful availment, where the plaintiff is required to show that the defendant purposefully availed itself of the jurisdiction of this court by proving that the defendant's website is for a commercial activity, it has made contracts with users in Dildar, and it has caused injury to the plaintiff by hijacking clientele. As all these 3 tests are fulfilled, the court, in my opinion, would have complete jurisdiction. Moving ahead with the second issue that deals with the applicable standards for entertaining a suit where more than one litigant is a foreign entity. In our case, there are 2 foreign litigants, Kanak Web Services, the plaintiff, and Google LLC. In Edkal, the locus standi of suits filed by foreigners is governed by Section 84 of the CPC. And according to this, the present law is that a foreign company can sue an Edkal-based company in our country before a competent court. As is already established in the previous issue, if the cause of action has arisen in Edkal, the court can proceed against non-resident foreigners also. So the nationality of the parties, in my opinion, would have no relevance in the instant case. The defendants have also argued that the plaintiffs have not got their trademark also registered in Edkal. But the thing is that our country has grown as a global economy. The public is very, very, very aware of foreign brands. So foreign claimants can prove trans-border reputation of their marks in Edkal. They can sustain an action for passing off on the basis of their trans-border reputation. And in the case of DRS Logistics, the Delhi High Court had also entertained Google LLC being made a defendant, and they'd even passed a judgment holding them liable. So the present suit is maintainable. On the third issue of whether the 2017 amendment is violative of Edkal's TRIPS obligations, I find that there are some elements that are violative of the TRIPS agreement. For instance, Section 2ZG of the Trademark Act 1999, it defines a well-known trademark to be a mark which is known to the substantial segment of the public. As per Merriam-Webster's dictionary, the word substantial means something which is considerable in quantity, something which is significantly great or large. But Section 11, subsection 6 requires the registrar only to look for knowledge among the relevant sections of the public. And this can become a major discrepancy. Additionally, the 2017 amendment allows applicants to file an application before the registrar for grant of well-known status. But the fear is that it places immense powers in the hands of the registrar, who may decide according to his own whims and fancies. Insofar, Rule 124 Clause 4 states that the registrar may invite opposition, which implies that this process is not mandatory, it is discretionary. Thus, a right to fair hearing, which is a principle of natural justice, may get violated. Section 11, subsection 5 of the Trademark Act makes it clear that for a mark to be given a well-known status, the procedure requires opposition. It requires rectification. It requires infringement proceedings. And the amendment makes the process simpler and prone to errors because it allows a trademark to be recognized as well-known by simply making an application to the registry. Additionally, because the trademark rules are delegated to their parent statute, the Trademark Act of 1999, they must derive their legitimacy from the parent statute. But in this case, the rules do not give the central government the authority to create an entirely new procedure for recognizing well-known trademarks. That too, when the procedure is non-adversarial in nature. This procedure leaves a lot of room for human error, room for corruption. And so the amendment is violative of Edkal's TRIPS obligations. It is discriminatory in nature. The fourth issue that we come to is whether the use of trademarks and meta tags and adverbs by the defendant amount to an act of unfair trade practice. Now, the plaintiff had argued that the defendant has used their proprietary marks as meta tags and bought them as keywords under the adverbs policy, while the counsel for the defendant relied on a number of foreign judgments to show that the use of trademarks as meta tags and keywords were not used under Section 2 of the Trademark Act because they remain invisible to the end user, so there cannot be any likelihood of confusion in the minds of the end users. And after perusing these judgments like Veda Advantage, Reed Executive, and Moscow City Arbitras, I remain unconvinced as to their relevance to the situation in EDGIL. Laws in nations like Australia, America, New Zealand are very different from that we find in EDGIL, and they cannot be applied directly. And this requirement of tangible representation under Section 2 cannot be given a narrow interpretation because otherwise it would defeat the very legislative intent of strengthening trademark rights. In my opinion, what cannot be done directly cannot be done indirectly also. So when an unsuspecting end user types his query in the search engine, he would naturally blindly trust the search result which is generated by Google. He would click on the websites which come up first. He would have no mechanism to verify the veracity of that website. So the invisible use would cause confusion in the minds of the users. And if it is allowed, it would mean that the court is legitimizing the illegal act of hijacking clientele and riding on the rival's reputation. This viewpoint of mine is also supported by judgments given by the Bombay High Court in People Interactive case and in Jayant Agarwala case. So in my opinion, the Defendants Act is a direct infringement and it amounts to passing off. This fifth issue deals with whether adopting a similar domain name by the defendants amounts to creating confusion and is an act of passing off in the digital space. Now, the plaintiff has argued that the domain name adopted by the defendants is deceptively similar to that of the plaintiffs. It is creating confusion in the minds of internet users, and hence it should be declared as an act of passing off. It is my opinion that every website has a domain name that acts as a user-friendly IP address. And while traditionally domain names just provided computer addresses, with rise in online commercial activity, domain names have actually become business identifiers. And in this sense, both domain names and trademarks are inherently serving the same purpose. They're identifying the goods of the owner. So I'm inclined to agree that the trademark law can be applied to domain names also. And in order for a domain name to be regarded as a trademark, it must be unique, it must be capable of distinguishing itself from the goods and services of others, and it should act as a reliable source identifier on the internet. In the present case, the plaintiff had registered their domain name as kws.co.ae, while the defendants have a domain name as kws.koshish.co.ae. The plaintiff is a company of global standing. It has flourishing global clientele. They registered their word marks, Kanak Web Services, as well as KWS way back in 2008. So in that sense, the word KWS is not generic in nature. It acts as a unique name which distinguishes their services from those of others. And in these circumstances, the role played by defendant would amount to an action for passing off. The chances of confusion also increase because both the parties are giving similar cloud-based services. Secondly, on searching KWS on search engines, the defendant's website also gets listed in top search results and sponsored links. And there is a general lack of digital literacy in our country, which means that users would not be able to differentiate between the two websites. Therefore, I hold that the domain name used by defendant amounts to passing off. Coming to the sixth issue, of whether Kanak Web Services can claim well-known status in EDGIL based on their trans-border reputation and prior registration of the wordmark Kanak Web Services. Well, to start it, I must say that today's physical boundaries between nations have become blurred due to globalization, due to internet, and goods and services which were produced in one country are being circulated worldwide. And in order to avoid any conflict in the global arena, the concept of trans-border reputation and goodwill was introduced. Now, the learned counsel for the defendant has argued that Kanak Web Services do not have a market in EDGIL, so they should not be given well-known status. On the other hand, the learned counsel for the plaintiff has relied on their trans-border reputation on the basis of the advertisements that they've made in our country to seek a well-known status. If you look at the TRIPS agreement provides that for grant of well-known status, there should be knowledge about the brand among the relevant section of the public, and that evidence is not limited to the actual use of the mark. It also extends to the knowledge gained through promotion or advertisement of the mark. So for example, if a company like Chanel, it does not sell its bags and perfumes in our country, but if it has advertisements in newspapers and magazines that are circulated in our country, it would still be eligible for getting a well-known status. Courts in EDGIL have also taken a liberal approach. They have made no distinction between goodwill and reputation. And so applying this to the present facts, I feel that the claimant, although does not have a registered office, it is not carrying on business in EDGIL, it had registered its word marks way back in 2008. They have been used in the course of trade openly, continuously, and extensively across all countries. The brand has been vigorously been promoted and publicized through print, television, and online advertisements. So given these advertisements, as well as the global standing and popularity of the plaintiff, I'm entitled to hold that the claimant's brand has recognition in ethical and must be granted a well-known status. On the seventh issue of whether any liability can be attributed to Google Ethical and Google LLC, I find that the counsel for the plaintiff has argued that attributing liability to Google is necessary to ensure the effectiveness of this court's judgment. And to this point, I dearly agree. For imagine a scenario where the third-party infringers use the platform of Google to showcase their infringing advertisements. Now, the plaintiff would run to court. They would want to get a court decree in their favor. But even if they get a court decree in their favor, the infringing material may continue to appear online unless some restrictions and some liabilities also imposed upon Google to remove them. The learned counsel for Google has argued that Google is just an intermediary, so they should have no liability. But I'm not inclined to accept this view because Google is a direct beneficiary. It makes monetary profit by conducting a sale of keywords. In fact, this can be seen prima facie from the fact that advertisers who compete with one another bid upon the basic price, which is fixed by the search engine for selection of the keywords, and parties can advertise their services on the sponsored links by paying necessary charges to Google. These keywords are also available on Google-owned properties like YouTube or even Google partner sites like NY Times or families.com. So linking section 79 subsection 3 of the Information Technology Act, Google itself provides a service of keywords. It selects the people who can participate. It actually shepherds them through the entire process. It conspires and abets the commission of unlawful acts. So Google cannot claim relief under section 79 as it has also not exercised due diligence. Another point that I wanted to point out was the plaintiff's counsel argued that until 2009, the AdWords policy applicable in ethical did not allow the use of trademarks as a part of keywords. But on June 4, 2009, the company unilaterally changes its policy and it decides that it will allow the use of trademarks as keywords in ethical. The prior policy acts as a direct admission of Google that use of trademarks as keywords amounts to trademark infringement. So the rule of estoppel should now prevent
I think your time is over. That's what it says on the chat, including the 2 minutes extension.
If I could just request the marking judges, I'll just conclude in 1 minute.
You will have time to get back. Yeah. Okay. Thank you. Can I ask the organizers to just put the judges in a separate room for the minute? I need to have a quick discussion with them.
Sure, sir. Sure.
You can just quickly do that.
Yeah. So actually, you'll already have the option to join the breakout room. You need to click at the option of breakout room below and y'all will be able to go to the...
We don't have the option for breakout room.
At the bottom, right next to the share screen button.
Nope. At least I don't have it.
All right, I'll just go to that.
So kindly check now. I've assigned it. Ms. Mondal,
Participants, the judges will, as they mentioned, just have a word and then we'll start again. Right? Ms. Mondal, we've assigned the room. Ms. Mondal, we've assigned you to the judges' chambers.
Yeah, but it's automatically returning back to the main session.
Could you just try joining again? I've
Yeah, sure.
just rechanged the assignment.
Yash, are you there?
Yes, sir. So can you hear us?
Yash, are you there?
Yes, sir.
Yeah, so I think Ms. Mondal gave you some instructions, right?
Yes, sir. We just received them.
Yeah, so could you tell the teams to get that going and mail it back to us before we proceed with the balance issues?
Sure, sir. We'll just get that done.
All right. Okay. So participants, the judges would like you all to fill in a form. We will send it across to you over email. Fill it and send it across to us, and then we'll proceed with the balance. All right? Thank you.
Participants, you have just been sent a mail with an Excel sheet. Kindly fill it and send it back to us.
What's happening? Are we back on track?
Yeah, we are back and we are waiting for the participants to fill up that form. And so is also. Yeah.
Okay.
Participants, once you have sent the form, you can just drop it on the chat that you have sent it across. Okay.
For the sake of continuing with the process, can I just request the researchers to fill up the form and drop it in the chat? And the speaking judges can continue. It'll just give us a heads up. So first of all, I apologize to Team 28 and Team 26 to just kind of interrupt this process in the middle. I'm sorry, but it'll just help us as marking judges to get a sense of what exactly you are or which position you're taking on your judgment here. So if the speaking judges could continue and whether the researching judges could just fill up that form and drop it on chat, would that be okay?
Well, I believe that would be fine. Team 25 has stated they've sent it across. Team 28 researcher and team 26 researcher.
So it's okay. They can send it in due course. We can start hearing them as they start. Yeah. So if it's okay with everybody, we can start hearing team 26.
Do we ask for the explanations or the clarifications now, or do we move on to the next team? Yash, can you clarify once?
Sorry?
Do we continue with the same thing, move on to the comment section, or do we move on to the next team?
We'll have to continue with the presentation session as two teams are yet left to present. So once they're done, then the round can proceed in due course.
Okay, sure.
So the next speaking judge can begin.
A very good afternoon to the marking judges and the brother and sister judges. I am member judge representing team 26 in the present case of Kanak Web Services versus Koshish Web Services and others. A total of 7 issues have arisen in the present case, and after hearing both the sides, the court is here to deliberate upon the same. The primary issue in the present case is regarding the jurisdiction of the High Court of Dildar based on internet or web presence of the litigants. Firstly, I would like to refer to a Supreme Court judgment of 2015, Indian Performing Rights Society Limited versus Sanjay Dalia, where it has been held that Section 134 of the Trademarks Act 1999 is an additional remedy for institution of trademark infringement or passing off suits and with Section 20 of CPC, where a civil suit can be filed where the defendant carries on business. Now, to analyze the term carries on business in internet-based businesses, I have analyzed the 2 judgments of Delhi High Court. Firstly, World Wrestling Entertainment versus Reshma Collection, and secondly, Icon Health and Fitness versus Sheriff Usman. And I have come to the conclusion that the availability of transactions through Koshish Web Services website and Google Ads website, that is defendant's website, that can be operated and accessed in the Republic of Ektal is virtually the same thing as a seller having shops in that place in a physical world. Therefore, the defendants are in fact carrying on business in Airtel, and hence this court can entertain the present matter under clause B of section 20 of CPC. Moving to the second issue that pertains to applicable standards for entertaining a suit based on use of trademark on a website of foreign litigant. Firstly, relying upon Banyan Tree Holdings versus A. Murali Reddy, I have concluded that the purposeful availment of jurisdiction of High Court can give this High Court the jurisdiction to entertain the present matter. For purposeful availment, three things have to be proved. Firstly, specifically targeting the audience of the Airtel. Secondly, entrance of commercial transaction with the user. And thirdly, leading to an injury to the plaintiff has to be proved. Now, in this present case, Google has specifically targeted the audience of Airtel by their Airtel specific advert policy, or the establishment of Google Airtel in the territory of Airtel, and has also commercially transacted with defendant number 1 through their Google AdWords programs. And this has led to the diversion of traffic from plaintiff's website. Similarly, defendant number 1 has entered into commercial transaction with its client and has specifically targeted Airtel, which has led to the tarnishing of goodwill and reputation of the plaintiff. Secondly, the cause of action shall arise everywhere where trademark is being used as meta tag or keywords for advertising, publicizing, or promoting any goods or services. Therefore, the High Court of Dildar in the present case can entertain the present suit under section 20C of the CPC, which provides for institution of suit where the cause of action has partially or wholly arising. This view has also been supported by Burger King Corporation versus Techchand Sheva Kramani case of Delhi High Court. Lastly, the place where injury is caused due to use of trademark shall also have jurisdiction to entertain the present matter, as has been supported by Millennium Copthrone International Limited versus Aryan's Plaza case. Moving to the third issue. The third issue is regarding the validity of 2017 amendment rules. Rule 124 of Trademark Rules 2017 directs the registrar to abide by Section 11 of Trademarks Act 1999 for declaring well-known status of trademark in Airtel. Now, the bare reading of Article 16 of TRIPS Agreement and Clause 6 of Section 11 Trademarks Act 1999, it can be concluded that both of the provisions are similar in nature. Therefore, it is neither a violation of TRIPS Agreement, which provides for protection of registered as well as unregistered trademarks, nor does it violate CPA TDS that provides for protection of IP owners specifically. Am I audible to the judges? All right. Further, the compliance of TRIPS agreement has also been stated under 88th report on patents and trademark system in India by Parliamentary Committee. Moreover, clause 9 of section 11 of the Trademarks Act states conditions that are not to be regarded for declaration of a well-known trademark. That includes use of trademark in Airtel, registration in Airtel or any other country, application of registration, and well-known status in any other country. Therefore, I fail to understand any scenario for which these rules are being claimed discriminatory in nature by the plaintiff. Coming to the fourth issue. In the fourth issue, to prove that use of trademarks as meta tags and keywords, the plaintiff has presented evidence that when KWS is searched in a search engine, defendant number 1's website and advertisements are shown at the top of the internet search result. And this has resulted in diversion of traffic from the plaintiff's website. Such use of trademark amounts to unfair trade practice as defined under Consumer Protection Act, as falsely representing the services to be related, approved, affiliated, or sponsored by third party. Here, the third party would be plaintiff whose reputation and name is in question. Such use also amounts to confusion among consumers and passing off of third party trademarks, as has also been viewed in People's Interactive versus Gaurav Jerry case and DRS Logistics versus Google India's case. However, have not accepted the argument of plaintiff for use of trademark Kanak Web Services, the trademark Kanak Web Services as meta tags or keywords, for plaintiff has failed to support this argument by any evidence of showing that Kanak Web Services is being used as meta tag or keywords. The fifth issue relates to the use of trademark in the domain name registered by Koshish Web Services. The domain name of defendant number 1, that is kws.koshish.co.ae, is clearly using KWS in their website, which amounts to using of trademark without authority. This use may cause confusion to the consumers and would amount to diversion of business from the plaintiff's website and would irreparably damage the reputation and goodwill of the plaintiff. This view has been also supported by numerous Indian High Court's judgments and even WIPO judgments, including Tata Sons Limited versus Manu Kosri, Tata Sons Limited versus Ramada Soft, and Bajaj Electricals versus Gaurav Bajaj. Moreover, the similarity in the services on the website, use of similar top-level domain, and use of dot after KWS shall additionally amount to confusion by highlighting KWS in the domain name of the defendants. The sixth issue pertains to whether well-known status can be claimed based on trans-better reputation and prior registration. The authority referred in this issue is Supreme Court decision in NR Dongre versus Whirlpool Corporation, where the court has granted well-known status based on trans-border reputation, and not considering that the use of the trademark should be in the territory where this claim has been made. The trans-border reputation in the present case is inferred from various registrations of the trademark of the plaintiff in across the globe, the jurisdiction across the globe, and knowledge in India by the advertisements made in print, television, etc. by the plaintiff, and the millions registered viewers and visitors on the plaintiff's website. However, prior registration of the trademark or any other country is not a condition for granting well-known status under clause 9 of Section 11 of Trademarks Act 1999. Therefore, a claim of well-known status based on prior registration is not valid to grant well-known status to a trademark. The final issue is regarding the liability of defendant number 2 and 3. I have relied upon DRS Logistics versus Google India, where it has elaborately discussed two major things. Firstly, defense granted to intermediaries against third-party offenses cannot be taken in involvement of any unlawful activities. Secondly, since Google is gaining monetary benefit from suggesting and inducing its users to use third-party trademarks, defense under Section 79 of IT Act, Information Technology Act 2000 cannot be claimed. Additionally, the fact that in other jurisdictions like European Union, Google investigates whether a keyword is infringing or passing off third party's trademark or not, there is no reason as to why it cannot be done in ICTIL as well. Therefore, I am of the view, I would request the marking judges just for an extension of 1 minute, and I'll wrap up with the whole conclusion. Thank you. Therefore, I am of the view that Google's advert policy is invalid, and Google should be directed to investigate in matters where third-party trademarks is being used as keywords. Lastly, since the advertisers through oblique motives is cashing upon the goodwill of the trademark owner for his own benefit, and through this process, Google is also earning revenue, Google should be equally held liable for the omissions and commissions of the advertisers. Concluding, I am of the view that the defendant should be permanently injuncted from using the mark KWS in any form or business or activity that shall amount to trademark infringement or passing off. Moreover, Google should be directed to remove all advertisements of defendant number 1 using plaintiff's trademark from its browsers and websites, and refrain the advertisers from further using the third-party trademarks. That was my presentation regarding my judgment.
Thank you.
If I have the permission of the judges, may I begin? Hello and a good afternoon, a very good afternoon to the marking judges, the fellow sister judges, and the honorable court clerks present in this court. After careful consideration of the facts and cases before me, and after hearing both the parties on merit, I will now pronounce my judgment on this case. As far as the first issue is concerned, whether this court can entertain the present suit based on the fact that this jurisdiction is this jurisdiction is to be given on the internet or web presence of such parties and not on their physical presence. I find no hesitation in entertaining this case based on the internet or web presence of the parties and making explicit departure from the general law as to territorial jurisdiction, as was held in the 2009 landmark judgment of Banyan Tree Holdings versus A. Murali Krishna Reddy. I have referred to the three tests and the three criteria. One, that the website is of a commercial interactive nature. The second one is that it is registered in ETHCAL and accessible in ETHCAL. And the third one, that there is prima facie an assumption of specific targeting done by the defendants in against the plaintiff's website. Therefore, I found no hesitation in accepting this case. As far as issue 2 goes, what the acceptable standards for entertaining a suit based on the defendant's use, infringement, or passing off, where more than one litigant is a foreign entity are, I have referred to the cases of Tata Sons Private Limited versus Hakuna Matata Tata Founders, and the case of India TV Independent News versus India Broadcast TV. And I have laid down the three criteria, the three applicable standards, the first two of which are applicable to this case, and the third one is applicable in cases where territorial jurisdiction applies. The first one is the accessibility of the website. The second one is that mere accessibility is not enough. There must be something more substantial indicating some purposefully directed activity towards the jurisdiction. And the thirdly, when there is territorial jurisdiction, which I again would like to clarify, not in this case, we need to find where the cause of action arose by tracing back the events as mentioned in the Distillers Company Limited versus Thompson case. Now, as far as issue 3 is concerned, whether the 2017 amendments by the Republic of ETHCAL to its trademark rules, whether they are violative of ETHCAL's TRIPS obligations and whether they are discriminatory, I have come to the judgment, I've come to the judgment that these 2017 amendments are not violative of ETHCAL's TRIPS obligations. I'll explain my train of thought how I reached to this conclusion. I first referred to what ETHCAL's TRIPS obligations are. Firstly, the TRIPS obligations in the Article 16.1 accords a member state, the privilege to accord rights to unregistered trademarks. This has been duly followed by incorporating the process of well-known trademarks and giving the right to the registrar through the 2017 amendments. Then we have Article 6 bis, which is the right of any person from any signatory state of TRIPS to challenge the registration of his mark in that country. Now we find that this also has been duly followed because the 2017 amendments have due provisions for incorporating well-known trademarks and objections for this. As far as the third obligation goes, it is Article 42 of TRIPS, which mentions the civil and administrative procedures and remedies. I find it important to mention that the 2017 amendments do mandate proofs being given alongside their application, and there is ample time provided for the general public against grant of the same. There is a public notice has to be issued. So I find that these amendments are only in furtherance and not in violation of ETHCAL's TRIPS obligations. Now, moving on to the fourth issue, whether the use of meta tags and AdWords by cautious web services, whether this to better search results, whether this amounts to an act of unfair trade practice. I'd like to mention here firstly that trademarks not only serve a private purpose, which is to protect the rights of the trademark owner. Trademarks also have a public purpose to their very essence, which is to protect the rights, and the trust which the general public has over the trademark. I have referred to the international law applicable here, which is clause 3.1 of Article 10 bis, which talks about confusion by any means with the industrial or commercial activities of a competitor. Here I have divided this issue into two sub-issues, which is one pertaining to AdWords and the second one pertaining to meta tags. As far as my chain of thought pertaining to AdWords goes, I have referred to the Competition Commission's case of matrimony.com versus Google. This is a rather important case with very similar facts, wherein the defendant used the AdWords of the plaintiff. And the Competition Commission held that such things allow the competitors of a particular brand to unduly benefit from the latter's reputation and goodwill. And this is an impediment to fair competition. I further referred to the case of Consim Info Private Limited versus Google India of the Madras High Court, which said that a trademark can be protected if it has acquired some distinctiveness, that is secondary meaning. Now, keeping into mind the fact that Kanak Web Services had been advertising worldwide very extensively and had 25.2 billion, which is a rather, it's an unusually huge number of visitors. They had 20 million registered users, and they had some reputation in the minds of the people of Etkal, and they had been using this mark openly and continuously. Keeping these things in mind, keeping Article 10 bis, the matrimony.com and Consim case, I have concluded that the use of similar AdWords would amount to an unfair trade practice. As far as similar meta tags go, I first referred in paragraph 22.1, the case of Opedal and Larsen versus Advanced Concepts, which was the first case. It's a 1999 case. It was the first case of similar meta tags being used by the defendant. Here, the court ruled in favor of the plaintiff. I've also applied Article 3.1 of 10 bis here again because it has applicability. And I have referred to the Bombay High Court case of People Interactive Private Limited versus Gaurav Jerry and others. This is called as the Shadi.com case also. In this, the court held that using the same meta tags is equal to attempting modified misappropriation of the plaintiff's mark. Therefore, we can look at the facts, and after analyzing that, Koshish Web Services tried to unfairly or dishonestly associate themselves with Kanak Web Services by using meta tags and AdWords. I have concluded that the use of meta tags and AdWords similar to their proprietary marks is an act of unfair trade practice. Moving on to the fifth issue, whether adopting a domain name by Koshish Web Services, which is similar to that of Kanak Web Services, whether this is an act of passing off in digital services. I have referred to the Delhi High Court case of Science Olympiad Foundation and held that acronyms are granted the same protection that trademarks are, because the case in question here, we have an acronym, which is KWS. Then I have referred to the Supreme Court's landmark judgment in Satyam Infoway Limited versus Sifinet Solutions, wherein it was held that domain names have equal protections as that of other trademarks. I have also referred to the ICANN's Uniform Domain Name Dispute Resolution Policy, whether to confirm whether the mark was used in bad faith, whether this domain name was used in bad faith. And I have concluded that after passing the tests, this mark was used in bad faith. After using the 7 tests laid down in the case of Caldila Healthcare versus Cadila Pharmaceuticals, I have concluded that after passing these tests, Koshish Web Services is liable for the act of passing off in digital services, in the digital space. As far as issue 6 is concerned, whether Kanak Web Services can claim well-known status in the Republic of Etkal based on trans-border reputation and prior registration. I have looked at this issue in 2 sub-issues. One is pertaining to trans-border reputation, and the other one is pertaining to prior registration of wordmark. Then I have referred to what the current standards pertaining to well-known trademarks are to check whether by the current law of India or Etkal, does Kanak Web Services deserve to be a well-known trademark. I have referred to section 11 in the Trademarks Act, rule number 124 of the trademark rules, and the public notice by the Ministry of Commerce on May 22nd, 2017. And then I have also referred to the Japanese law, which is the reason I've done this is because Japan is also a signatory to the TRIPS, and I've checked what the standards are for Japan to how they have furthered the spirit of the TRIPS agreement. And after looking at that, and also after looking at the case of ISKCON versus ISKCON Apparels, this case which has solid persuasive value here, I have concluded without any reservations that trans-border reputation is a basis for claiming well-known status for a trademark in the Republic of Etkal. Now, looking at section 11.9 of the Trademarks Act, read along with rule 124 of the trademark rules, I have concluded that prior registration is not a consideration for granting well-known status. Now, as far as issue 7 is concerned, the last issue, whether any liability can be attributed to Google Etkal and Google LLC, I've held that Google Etkal and Google LLC cannot be held liable for allowing keywords which are identical or similar to the proprietary marks of others. I have first looked at Section 79 of the IT Act, and it has provided immunity to intermediaries from liability for the kind of information, provided that they comply with the the clauses that are mentioned here. And Google does comply with the clauses here. Then I have referred to the very recent Intermediary Rules 2021, Section 3(1)(b) to be precise. May I please be granted 1 minute to conclude? Thank you. And I have this section 3(1)(b) of the intermediary rules. It mandates the user to it mandates the user agreement to not to inform the user to not host, display, upload, modify, publish, or transmit any information that infringes any patent, trademark, copyright, or other proprietary right. Now, I've looked at Google's terms of services and concluded that Google has shown the diligence which is due towards it by application of Section 3(1)(b) of the intermediary rules. And therefore, I have confirmed that Google is not liable for allowing keywords which are identical or similar to the proprietary marks of others. Then one more thing that is to be mentioned here is that it is, even speaking logically, it is somewhat unreasonable to expect Google to verify every single mark, of which millions of which exist, and to check them with the trademark registry. Thank you.
Are we moving on to the next segment, next rounds?
Do I have the permission from the marking judges to commence with the commenting section?
Sure, yeah.
Thank you. I would like to first begin by appreciating the extensive research done by my brother and sister judges. They have used various judgments to establish their stance in their memos. I have certain clarifications that I seek from both of them. So for team 26, my first question was in issue 1. In their memo, they've mentioned section 134 of the TM Act, and they have tried to show that the jurisdiction would lie with this court under section 134. And according to my understanding, the plaintiff does not reside in Edkil, does not carry on any business in Edkil. So I would like to clarify from them how they're connecting section 134 with jurisdiction, and why not place more reliance on section 20. The second issue that I have is they have placed reliance on section 20, subsection B, that the defendant carries business in Edkil. However, they've relied on World Wrestling Entertainment versus Reshma Collection, and they've said that since a contract has been concluded in Dildar, the High Court of Dildar would have the jurisdiction. But my question is that the facts mention that no actual contract was concluded in Dildar by the users with the defendant. So why not apply section 20 subsection C, that is where the cause of action has arisen in Edkil. On the third issue, they've held that they do not find the 2017 amendments to be violative of the TRIPS agreement. However, we urge them to look at Articles 3 and Article 4 of the TRIPS agreement and clarify as to why they feel that appointment of the registrar and the power given to the registrar to accept well-known status, how would it not affect the parity of treatment that is meted out to other nations also? This third, for team 28, my first question is, under issue 2, they have not made Google LLC to be a party to the suit, because they feel that Google LLC, being a foreign litigant, it does not come under the jurisdiction of this court. However, if they've read BRS Logistics and the Delhi High Court judgment, the Delhi High Court did consent to Google LLC being made a litigant, being made a defendant in the present case. So my question to them is, on what basis have they not given consideration to this case, which is a very recent judgment? Again, on issue 3, I have the same question as I had with the other team, that they've not found it violative under Article 3 and Article 4 of the TRIPS agreement. For issue 7, my question is that in their memo, they had given that Google has an indemnification clause with the third parties who advertise on their platform. So my question is, how can Google, by its own policy, absolve itself of any liability on the digital space? Secondly, let's say, even if we assume that we allow it to happen, we have to consider that it would lead to future violations. And as a responsible court, we have to ensure that we stop that policy which leads to future violations, which is not actually taking into consideration due diligence. The next thing that I wanted to point out was, even if a contract of indemnification exists between Google and the defendant number one, and even if Google is held to be liable to pay in the present case, they can invoke the indemnification clause in another case proceedings, and they can ask defendant number one to cover the losses from them. So that could be an option. Additionally, I want to ask them for any legal backing, any judgments that they have considered while allowing Google escape because of the indemnification clause. Additionally, the clause of the policy of Google that they've mentioned is unnumbered in the memo. And so we needed that number of the clause so as to determine its veracity. One more thing that team 28 had mentioned in their oral submissions was that it's not possible for Google to check thousands and hundreds of complaint cases for trademark infringement that come to them. But my point is that in countries like European Union countries in EFTA region, Google is not allowing trademarks to be used as AdWords or as keywords. So my question is, if they can do it in those countries, why are they not wanting to apply the same policy in a less developed country like Italy? Thank you.
Thank you, Team Judge from Team 25. Should I start with my comments on the judgments, marking judges? All right, thank you. Before starting, I would like to answer certain questions posed by Team 25. Firstly, I have not stated that the court has jurisdiction under Section 134 of Trademarks Act. If the member judge could identify the paragraphs which state that, in my judgment, which state that I have stated that jurisdictions come under 134. In my presentation as well, I've stated that the jurisdiction of the present court is under Section 20 of CPC, Clause B and C. Secondly, with respect to Section 20B of CPC, I have referred to World Wrestling Entertainment case, where it has been stated that even though the defendants are not residing in Delhi, but if they're offering their services, trade services, through online applications and e-commerce portals like www.amazon.in or Google Pay or etc., which can be accessed and operated from all over the country, here ICTL, including Delhi, in such cases, the defendants will be set to carry on business in the territory of the forum court. And hence, I have stated that the present court would also have jurisdiction under Section 20B, which states that if any of the defendants carries on business in a place, the suit can be instituted there as well. Lastly, with respect to issue number 3, before answering the question with respect to issue number 3, I would like to raise a question which has been raised in the previous deliberation rounds. And I would like to know the viewpoint of both the sister judge and the brother judge, that whether this commercial suit, we can adjudicate on the matter of validity of a law. Although none of the brother judge nor the sister judge nor have I referred this contention in my judgment, but it's an important issue to be raised here since we are deliberating on it for the past 2 days. Therefore, I request the brother judge and the sister judge to clarify on what is their viewpoint, because I am of the point that in this commercial suit, we cannot adjudicate on the validity of a law since it's a commercial suit. Right. Now, moving to the comments on the brother and sister judges' judgment. Firstly, with respect to Team 25, I agree with the reasoning which has been presented by the sister judge in issue number 1. Only, again, I would like her to appreciate that Section 20B, under Section 20B also, the court has jurisdiction, as has been stated by me in my presentation and earlier right now. With respect to issue number 3, as I have already posed the question, I would although like to answer that just because the power is given to the registrar and some unlawful persons have abused in past this power which has been granted to him in the cases of the registrar, which grants the well-known status. It cannot make a law discriminatory in nature. It might be inappropriate, but it wouldn't be discriminatory of TRIPS agreement and discriminatory in nature. Furthermore, as I've stated earlier also, trademark law in ICTIL is in fact in agreement with TRIPS agreement, as has been stated in Parliamentary Committee's report. Further, moving to issue number 6, I would like to point it out to Sister Judge to consider that under clause 9 of section 11 of Trademarks Act, it states that registrar need not consider that prior registration of a trademark is there in cases in determining well-known status. And hence under issue 6, you cannot grant a well-known status based on prior registration, as it has been denied by law itself. Lastly, I would like both the brother and the sister judge both to elaborate on their view on the issue number 4 specifically with respect to use of Mark Kanak Web Services. I'm not talking about the use of Mark KWS as meta tags and keywords. I'm talking about use of Mark Kanak Web Services, which has been alleged by the plaintiff itself that defendants are using KWS and Kanak Web Services as meta tags and keywords. And hence, I would like both the brother and sister judge to elaborate as to how, what conclusion they have come to the issue that whether defendant is using Kanak Web Services also as meta tag of keyword. With respect to the judgment of team 28, firstly, I would like the brother judge to elaborate as to they have written in that DRS, they have not referred to DRS judgment. I would like the brother judge to elaborate as to why DRS would not be applicable here. Secondly, I would like to differ with the decision of the brother judge in issue number 7, where they have exempted the liability of defendant number 2 and 3 based on intermediary rules 2021 and Google's policy. Firstly, Google's policy is not the law of the land, and any party cannot form a policy and then claim exemption under that same policy. Moreover, as stated by me in my presentation as well, that such policy would be invalid. Moreover, the intermediary rules does not provide exemption from the liability of intermediaries. It merely provides an ethical code that which the intermediaries has to follow. The exemption of liability is given under section 79 of the IT rules, which states that this protection of intermediaries would not apply. The subsection 3 of section 79 states that the exemption which is granted to intermediaries for offenses of third party would not apply in 2 cases. Firstly, when the intermediaries has induced the commission of unlawful activities, and secondly, when even after coming to knowledge, actual knowledge, they did not remove or disable the access to that infringing material or infringing use of information which was done on their server, on their website. In the present case, Google has clearly induced the use of third-party trademarks as keywords and has also failed to disable the use of KWS as keywords when it was first notified about the act by the plaintiff, the suit which was filed by the plaintiff. It was notified to them regarding such an issue in April 2022 itself. I would just like to ask for an extension of just 1 minute, and I'll summarize the comments made. But right, thank you. Moreover, I do not believe that the defendant number 2 and 3 has done due diligence for under rule 3 of rule 3D of intermediary rules 2021 itself. It provides for that on being informed, the intermediary should stop posting such an infringing information, which has not been done by defendant number 2, which is Google ICTIL here in the present case. Further, I would like to differ from the opinion of the brother judge that Google LLC cannot be made a party to the suit, which has been stated in their judgment, because they are located outside the physical boundaries. It is important to refer to Banyan Tree Holdings case, whether jurisdiction based on universally accessible website or a foreign litigant can be accepted based on purposeful availment of the jurisdiction. In the present case, Google LLC has purposefully availed the jurisdiction of Dildar High Court by specifically targeting the Republic of Acton, by commercially transacting with defendant number 1 and through its advert program, and which has caused injury to the plaintiff. I would like both the judges to ponder upon these comments made by me and clarify the same if needed. Thank you.
May I begin with the clarification? I'd actually reserved my clarifications for the next round as per the rules of the forum. And I'd first like to point out the comments I have on the sister judges cases. As far as sister judge from team 26 is concerned, it appears that I am largely in agreement with sister judge on the points raised and the applicability of the cases cited in issue number 1, 3, and 6. As far as issue 2 is concerned, I would like to refer to paragraph 17 and 18, where the Honorable Sister Judge referred to the Exxon Mobil case and the Millennium cases, respectively, and said those courts shall have territorial jurisdiction within the local limits of which services are being offered. I would have agreed with this logic, but I differ in the conclusion which states that Koshish Web Services offers services in Etkal, thereby automatically conferring this High Court at Dildar jurisdiction. Just because Koshish Web Services is offering services in the country of Etkal does not automatically confer the High Court at Dildar jurisdiction, since Dildar is only one part of the country of Etkal. And Koshish Web Services does not have any clients or registered offices within the jurisdiction of this High Court at Dildar. In paragraph 18 and paragraph 33 of the fourth issue, the DRS logistics case has been mentioned, and it was also pointed out by Sister Judge as to why I have not referred to this case. Well, I did not find it appropriate to refer to the DRS logistics case here, which was a single judge bench of the Delhi High Court, because this DRS logistics case has made no mention whatsoever of the latest 2021 intermediary guidelines, which I have referred to in my judgment extensively as part of my reasoning of issue number 7. The single judge bench case has also, and I must quote it here, has been facing severe criticism from academia, and therefore I believe that as we are a 3-judge bench of the Dildar High Court, we should sidestep its application here, and this case does not stand valid per incurium. In paragraph 19, it has been mentioned that the use of ad text or ad title would amount to trademark infringement under section 29 of the Trademarks Act. I would like to point out that this section is only applicable to registered trademarks. As per the trademark rules 57 and 58, this trademark was not renewed, and therefore it was not a registered mark, and owing to its non-registration at the time of filing this suit. As far as issue 4 is concerned, it would have been better if the Honorable Sister Judge would have addressed the issues of meta tags and adwords separately, since both of them are conceptually different and have different jurisprudence applicable to them. In paragraph 32, we do not find any reference to the Amway case relevant, since it talks about section 29, again, which is only applicable to registered trademarks. There have been several cases which have been mentioned like this, and we do not think that these cases are applicable here because they were for registered trademarks for an action of trademark infringement, not passing off. For issue 5, I have a constructive comment for this issue. In paragraph 40, the case of Caldila has been mentioned to define passing off. The learned sister judge failed to look at the crux of the ratio of this case, which laid down the 7 tests of passing off, which I have discussed extensively in my judgment. In issue 6, we found a contradiction here in what is stated in paragraph 61 vis-a-vis what was stated in the oral submissions by the Honorable Sister Judge. The Sister Judge said in her oral submissions that prior registration is not a ground for grant of well-known status, whereas in the oral submissions, she has stated that it is a ground. So if the Sister Judge could clarify on this. As far as issue 7 is concerned, in paragraph 64, again, there has been made a mention to the DRS case, which I have already clarified. In paragraph 68, I would like to point out that the Honorable Judge has only mentioned that Google is liable, but failed to mention whether Google LLC is liable or whether Google Etkal or both are liable, as was the crux of this issue itself. Furthermore, we find holding Google liable to be unfair, as we have already mentioned in our judgment. As far as the sister judge from team 25 is concerned, I am in agreement as far as issues 1, 2, 4, 5, and 6 go. In issue 3, I have a contention that the sister judge has held that the 2017 amendments are violative of the TRIPS obligations and discriminatory in nature. The logic I believe here is not correct because sister judge has not compared these agreements vis-a-vis the TRIPS obligations of ETCAL one by one. In my opinion, the registrar of the trademarks being given this power is not unfair towards, and it does not give any arbitrary or unbridled powers to the registrar. And secondly, it's not against the principles of natural justice, which are followed universally, as was claimed by the sister judge. This is because from what the 2017 amendments have done is that they've made it easier for a national from another TRIPS signatory state to protect his rights. I'd like to remind the learned sister judge that before the 2017 amendments, a trademark could be declared well known only by observation of an Indian court. And this lengthy and convoluted legal process could only be afforded by certain corporations with deep pockets only. And this was generally avoided by trademark owners. This is evident from the abysmally low number of trademarks that are declared as well known, somewhere around 200 to the best of my knowledge. Learned sister judge has also contended that trademarks should not only be known to the relevant section of the population, it should be known to the public at large. Now, I find a flaw in this reasoning to be very apparent that an industry-specific trademark, something like the mark of a chemical, for say a chemical used to bond aeronautical parts together, howsoever well known it may be in the field of aeronautical engineers, may be altogether omitted from getting the benefits of a well-known mark. Just as lawyers are well-versed with the relevant marks like Westlaw and Manupatra, doctors do not know about them. Surely the learned sister judge does not expect lawyers and the general public alike to know about the brands of most well-known chemicals in aeronautical engineering. As far as issue 6 is considered, I agree with the learned sister judge on the conclusion that transborder reputation is a good claim for granting well-known status. However, she wholly missed out in giving her opinion on whether prior registration of a mark is a ground for well-known status, as I have come to the conclusion that it is not, even though transborder reputation is. Now, in issue 7, in paragraph 48, the learned sister judge has mentioned that Google selects the people who can participate in the process of acquiring keywords from Google. We find that this is incorrect since the way Google AdWords works, AdWords are allotted to the highest bidder and this bidding process is open to everyone. In para 48, it is mentioned that Google cannot be said to be an intermediary because it benefits from the direct sale of AdWords. Just because Google has a monetary benefit, it does not abjure the benefits of section 79 of this act. An intermediary is sort of a middleman, someone who charges for the services, and almost every single intermediary has to have some monetary gain. This is how these companies make money. I'd also like to disagree and refer to section 79 and of the IT Act read alongside with section 3(1)(b). Furthermore, as far as due diligence is concerned, I believe Google also provides for a complaint. Could I please have 1 more minute to conclude? Thank you. As far as section 79 of the IT Act read alongside section 3(1)(b) of the intermediary rules, I have set a standard of due diligence that is expected from Google. Such diligence is not supposed to be all-encompassing. It is limited by what Indian law says and what the laws of ETCAL say. So we have found that Google has complied to this, and Google has made it the responsibility of the advertiser to be diligent in this regard, because the advertiser is the person who is in the field of trade and has requisite knowledge of whether something is a trademark or not. As far as due diligence is again concerned, Google provides for a complaint portal for filing of cases where someone's IPR on a mark or a mark has been violated, and consequently I find the judgment given under paragraph 53 to not be really appropriate. I'd also like to point out one last thing, that in paragraph 53, the honorable judge has held that Google is liable without specifying again whether Google ETCAL is liable or Google LLC, as was specified. It would be great if the judges could clarify on this so we reach a conclusion. Thank you.
If I have the permission of the marking judges to start with the clarifications. Do I have the permission? Okay. Thank you.
Maybe we just like to ask you some questions here, if that's okay.
Sure, sir.
Yeah, I'd just like to put maybe the other marking judges can also. So I just got one little query here, which you could clarify. When one of the criteria for jurisdiction is injury, so could you clarify whether this injury is, this is not to any particular Judge, this is to all of you. Whether the injury demonstrates any element of mens rea in the context that has it, what if there is an inadvertent injury due to the action of Google, for example, in giving some meta tags, and is it not doing its ordinary business when it gives that? So how could you hold Google liable on that count? And I think this pretty much goes on issue number 6 or issue number 7 to teams 25 and 26, because it's an open market and it's very obvious that the other companies can also bid for getting those particular meta tags or AdWords. So just clarify that point in terms of what is your assessment of the business of Google. So maybe the other marking judges have questions, they could also raise them. We could clarify any points.
Yeah, I have. Do you want to clarify first, or should we go like one by one?
Whatever you suggest, ma'am.
Okay, you go ahead and clarify, then I'll go.
Maybe if we just put down all the questions in, and while they're clarifying, they could address these issues as well.
Yeah, we can do that also. So while you all were giving your judgments, I had one observation regarding the fact that this was a FTA and the rules were made pursuant to the FTA. What are the conditions which makes a FTA valid? Because some refer to non-discriminatory principle in, indirectly, but there was no discussion primarily on how FTAs are valid under the WTO. This is first. Second, I don't remember which team, but someone said trademark law can be made applicable in violations of the domain name. So and they refer to the Satyam CFNet case also. So in that regard, can we say that trademark registrations and domain name registrations are corollary to each other, or are they not? Third is the fact regarding what is the concept of bona fide user and what will be cautious registration of KWS as domain name? Will it come under the concept of bona fide user? And therefore the attempt by KWS, the original company, amount to reverse hijacking. This is in relation to domain name dispute. Also, when you are arguing that the advertisement, there were advertisements happening, can advertisement, any of the cases, because I was reading through the memos, so any of the cases which you want to highlight that advertisement is a sufficient ground to help further infringement of rights. On the 7th or the last Google writ issue, what is the role of Google exactly? And whether intention or mens rea is a requirement for infringement or for fixing liability in such issues. That is all for now. Also, one last, regarding unfair competition, there has been reliance on, some of the teams relied on cases and one on the Paris Convention. So a little deliberation on the Paris obligations and whether India is bound to follow such obligations or has embodied such obligations.
Do I have the permission of the marking judges to start with the answers? Okay. So the first issue, the first question that was raised was regarding issue 7 and the role, the mens rea that Google has while allegedly causing injury to the plaintiffs. So the first thing that I wanted to point out was that the learned counsel for Google had argued that Google is only an intermediary in the process, so they should have no liability. But if we look at the policy that Google has, we'll find that they are a direct beneficiary as they make monetary profit by conducting a sale of the keywords. I've asked my researcher to copy paste and put it on the chat box the verbatim parts of Google's policy that the court had found to be violative in DRS logistics case. The thing is that each keyword is bidded against a fixed price. And this can be seen prima facie from the fact that advertisers who vie with one another bid upon the basic price fixed by the search engine for selection of the keyword. And then parties can advertise their services on these sponsored links by paying necessary charges to Google. If we look at DR Logistics wording, it states that it is settled law that an average consumer in India is of average intent, that an average consumer in India is of average intelligence and imperfect recollection. So the case of Google as an intermediary is unmerited because there is an obligation on part of Google to ascertain that the keyword chosen by the advertiser is not a trademark. And even if it is a trademark, the same has been licensed or assigned. So not ascertaining this factum by Google, it cannot take the benefit of exemption under section 79 because it has not followed due diligence. Talking about mens rea, it's my opinion that the adverts policy of the defendant amounts to a form of blackmailing, where a company owning a particular trademark is forced to take a higher bid for its own trademark to ensure that others are prevented from using it. If they don't bid higher, then Google would let the competitors infringe their IP rights. And such a policy goes against the whole concept of sole use by the proprietor owner, and thus it should be considered illegal. Additionally, Google is the only one that can see the landing page, that is the website of the advertiser, which may contain the infringed trademark, and also the part where the website contains the keyword. So Google cannot absolve itself of the liability of ensuring that keywords do not infringe a trademark. And already as pointed out by my sister judge, if we look at the 2009 policy of Google, back then, Google would not allow the use of trademarks as part of keywords. But on 4th June 2009, the company decides to unilaterally change its position and they allow the use of trademarks as keywords in ethical. So the very fact that prior in time, they had admitted themselves that use of trademarks as keywords would amount to trademark infringement, the rule of estoppel should come in place and they should be prevented from claiming any relief in this court. And Google is still using its earlier policy in European countries in EFTA regions. So this shows a mens rea on part of Google that they are willing to reflect a higher duty of care in jurisdictions with stricter laws and where there is an internet literate population. This disparity in duty of care shown between the developed nations of the West and a developing nation like Ectel is actually quite disturbing, and so it should not be allowed. So this was my stance that Google should be held liable. They should be made to investigate complaints made by the plaintiff over the misuse of the trademark, and they should refrain third-party infringers from committing such violations by removing or blocking their advertisements. The second issue was related to domain names. So in this case, it is dealt under issue 5, I feel. And if you look at this case, the plaintiff is a company of global standing. They have a flourishing global clientele and all the services that they are providing is through their website. So the website becomes the most important form, the most important medium through which their services are being provided to the customers. They had got their trademarks, they had got their word marks, Kanak Web Services, as well as KWS registered in 2008. However, the registrations for these expired. So the word KWS can still be protected under passing off because it's an unregistered trademark. KWS, in my opinion, even though it's an acronym, it is not generic in nature. It acts as a unique name. It distinguishes their services from others. And therefore, I feel that the use of the domain name by defendant would amount to an action of passing off. Also, the chances of confusion happening are increasing because they're both in similar services. There's lack of digital literacy in our country. And the domain names are phonetically similar. If we see the domain name of the plaintiff, it is kws.co.ae, while the domain name of the defendants are kws.koshish.co.ae. So any reasonable man can infer that a user with an average intelligence and an incorrect or imperfect recollection would get confused between the two, would get confused between the authenticity of the two websites. The third issue was that was raised was related to advertisements and the emphasis that we can place on advertisements to prove trans-border reputation. So if we look at the judgments in Ectel, we find that in Ectel, a liberal approach was taken and the courts did not make a distinction between goodwill and reputation. According to the English jurisprudence, for goodwill to be proved, the foreign claimant has to prove that they have a business or a market in the disputed territory. But in contrast, courts in Ectel have considered the words goodwill and reputation to be synonymous. And to prove reputation, presence of a business in the territory is not required. It is sufficient to show that the relevant section of the public has knowledge of the brand, and this can be proved by showing evidence of advertisements. We can refer to the case of Kamal Trading Co. and Gillette UK Limited, where the question was whether the goodwill in the trademark 7 o'clock stood extinguished because of non-availability of those blades bearing the said mark in India. And the Bombay High Court held that they would not make any distinction between goodwill and reputation. And they held that because the product had been advertised in the Indian market, the brand can still claim transport or reputation because the general public in India knows about it. Secondly, in Whirlpool case, the dispute revolved around the mark Whirlpool for washing machines, and the claimants in this case relied again upon the advertisements made by their company in Ectel. Justice Lahoti of the Delhi High Court that time had ruled in favor of the claimant, and they had said that in spite of non-registration of trademark in India, the reputation of the plaintiff was traveling trans-border to India as well through commercial publicity made in magazines which are available or brought in India. In fact, in Playboy Enterprises versus Bharat Malik, the Delhi High Court was dealing with a case where the plaintiff's Playboy magazine was banned in India. But despite that, the Delhi High Court ruled in favor of the plaintiff, and they held that in the present day, even goods of unregistered mark and banned items like the one in the question get more in circulation, partly out of curiosity and mainly if they capture the imaginations of its consumers, and thereby they gain widespread reputation and goodwill among tourists, travelers, embassies, and even smugglers. So I hope I've answered all your questions.
I start with my conclusion around marking judges. Right, all right, thank you. So to answer the questions raised by the marking judges, firstly, regarding the liability of Google, firstly, to clarify, Google here means the liability of defendant number 2 as well as 3, Google Ectel as well as Google LLC. Now, to answer the question raised by the marking judge, that here Google is an intermediary as accepted, but it cannot be granted exemption under Section 79 of IT Act 2000 as has been claimed by Google. Now, in this case, as I've already stated, that Section 79 of IT Act provides two circumstances where such exemption from the liability of intermediaries for the offenses of third parties can be granted. Firstly, where the intermediary has induced the use of the commission of unlawful activity. Here in this case, since Google as an intermediary suggests the keywords and other words to the advertisers, plus they gain monetary benefit from the biddings used by the advertisers to gain that particular keyword. Here it can be said that Google is in fact inducing the third party to use inducing the advertisers to use third party trademarks as keywords. Moreover, in second circumstances, it is said that even after coming to actual knowledge, they did not remove or disable the access to that infringing material. Here, after filing of suit, Google has, the defendant number 2 and 3 has submitted their pleadings, have argued their side, and despite knowing that such an issue has arisen with respect to their keyword, they have not acted upon and have not investigated or not have acted upon to stop the use of such keywords in their AdWords program. And hence the liability of Google has to be taken into account here. Now coming to the question how FTAs are valid, how FTAs are implemented, I believe that FTA, free trade agreements are, and when entered by a country, the country has to make policy regarding the same to actually enforce the agreements in the country. So that was, I think that is what the marking judge asked. Moving to the second question, domain name registration and trademark. Here, it has to be stated that trademark is used to identify and distinguish any goods or services, and domain name is used to distinguish services of the trademark owner. And since domain name takes you to a particular to a particular website which provides a particular service, it's important for a domain name to be protected, and it is in fact protected in the Trademarks Act of 1999 in Ectel, Republic of Ectel. Moreover, with respect to bona fide user, I am of the viewpoint that Koshish Web Services is not a bona fide user. For it was in March 2022, it was the Kanak Web Services sent a restraining notice to Koshish Web Services, which made them aware about the fact that KWS is a mark of Kanak Web Services and not of Koshish Web Services. Despite this, they did not stop the use of KWS as a mark, and therefore I believe Koshish Web Services is not a bona fide user. Moreover, with respect to advertisements, advertisement is a sufficient ground to file trademark infringement for it amounts to use under section 29 in common law, section 29 of Trademarks Act and common law, as has been stated by Burger King Corporation, which lists down the meaning of the term use of a trademark, including use by affixing it to the products and services, use by offering goods and services, used in advertising. Therefore, Burger King is an authority where we can say that advertising can also be a ground for filing a trademark infringement suit. Moreover, with respect to Paris obligations, I am of the viewpoint that an international law can only be implemented in any country in India by transforming it into a domestic law. So by virtue of Article 253 of the Constitution of Ektal, Parliament can make legislation on the foreign treaties or agreements which they which they enter into. Therefore, unless the Parliament has made a law regarding the enforcement of Paris obligations or the TRIPS agreement, the validity of a law cannot be questioned with respect to an international law. Moreover, with respect to, I think that was all the questions raised by the marking judges. Or have I missed something? If at all, please let me know. All right. Just to conclude, I would like to state that I would just like to conclude my issues that firstly, intellectual property has in cases of intellectual property, the court should be should also be mindful of the fact that it is ultimately the public at large which gets cheated and feels the brunt of spurious goods and services in the market. Therefore, I believe that in the interest and in the light of arguments made by the plaintiff as well as the defendant, and considering the interest of public at large, I believe the majority of the defendant should be permanently injuncted from using the mark KWS, and the defendant 2 and 3 should be liable, contributory held liable for the omissions and commissions of the advertisers as well. And they should be directed to remove all the advertisements which are infringing or which are passing off the plaintiff's trademark. Yes, that was my conclusion for the judgment. Thank you.
If I have the permission of the marking judges, may I begin? It appears that I have 9 clarifications. I have 9 questions before me, and I'll take all of these clarifications one by one. The first one was why I have to clarify why I did not refer to DRS logistics case. Now, neither is the DRS logistics binding on this court, nor is it good law in my opinion, because this law, this case has made no mention wheresoever of the latest 2021 intermediary rules, which I have applied in my judgment, and therefore we do not believe. I do not believe that as a 3-judge bench of the Dildar High Court, we should be placing a lot of reliance on this case, as has been done by the sister judges here. I think this case is per incurium and is not good law. As far as why Google should not be held liable, in my opinion, I'd like to make this point clear again, that I have referred to the law of Etkal. What is due diligence? What due diligence is expected from Google in Etkal, and not compared it to whether what it is expected of in the European Union or somewhere else, because that makes no difference to us here at this point. The diligence that is expected is given in section 3(1)(b) of the intermediary rules, which mandates that the user agreement should inform the user to not host, display, upload, modify, publish, or transmit any information that infringes any patent, trademark, copyright, or other proprietary rights. Now, to say this in my own words, this puts an onus on Google. The only onus on Google is that they have to, in their AdWords policy, they have to mention clearly that you as an advertiser are responsible for whatever AdWords you are choosing, whatever AdWords you are picking, and therefore Google has done its due diligence. Also, as far as Sister Judge from Team 26 said, Google has not done its due diligence under Rule 3D of the Intermediaries Act. It appears that Google does have its resource centers everywhere, and Google has not been informed by an order of this court yet. Just because a case has been filed in this court doesn't mean that Google has been informed that there has been trademark infringement. It is well within our powers to send a personal notice to Google LLC, Google Ethcal, I'm sorry, and ask them to take this keyword down. And this is what has been followed along with Google's domestic dispute resolution forum, which Google has, in which they have a whole process for dispute resolution here. As far as this question goes, why Google Ethcal why Google Ethcal can avail this jurisdiction and not Google LLC? Because what we have done is we have placed reliance on the judgment of Tata Sons Private Limited versus Hakuna Matata Tata Founders. And what they did is that Google LLC was not made a party to this case, because even if we issue directions to Google LLC, we have no means to enforce it. And since Google LLC and Google India or Google Ethcal are parties, are companies which belong to the same parent organization, then we did not find it that Google LLC needs to be made a party to this case. Also, Team 26, Sister Judge, she said that Google LLC has purposefully availed. Now, the fact is that Google Ethcal has been the primary intermediary here, not Google LLC, because even the AdWords and everything, the meta tags, everything has been facilitated by Google Ethcal, not Google LLC in this case. As far as the question of what is the concept of a bona fide user and whether Koshish can be said to be a bona fide user, and will it amount to reverse hijacking here? Now, we do not think that Koshish will be a bona fide user, because we can see as the facts of the case, Kanak Web Services was extensively, openly, and continuously advertising for as long as a decade before Koshish Web Services, that too in multiple mediums, and they had 25 billion visitors and 20 million registered users. Now, for something to be bona fide, it is very difficult to call the actions of Koshish Web Services bona fide here, because being in the same pool of services which Kanak and Koshish provide, both of them, I think Koshish Web Services should have known about the existence of Kanak Web Services, and I find this to be a malified attempt by Kanak Web Services to unlawfully associate or dishonestly associate itself with with Kanak Web Services. As far as the question of can advertisers be held for ground for infringement of rights, no, we think they cannot be directly held as a ground, as this forms one of the criteria to help determine cross-border reputation, and cross-border reputation is a ground for claiming the infringement of rights. Now, I'd like to ask for the extension of a minute or two.
But not more than a minute, because we've given you a lot of to everyone. Yeah.
Just 1 minute and I'll conclude. As far as the question which was asked pertaining to the Paris obligations and whether India is bound to follow such obligations or whether it has onboarded on such obligations, in consideration of the provisions of Section 11, the registrar has the liberty to invite objections before declaring the marks to be well known. Now, I think this is somewhat on the same lines of the Paris obligations, and the final question as to whether the Satyam Sifinet case, whether trademarks and domain names are in collusion with one another, I think the answer is yes, because the primary question of Satyam Sifinet was whether a domain name can be granted the same protection as that of a trademark, to which the answer was in the affirmative by the Supreme Court of India. These were all the clarifications I had.
If I have the permission of the marking judges, I realized that I'd skipped one question because there were multiple questions and I lost out on the number. So could I please address one question which was raised regarding issue 3?
I think we are done with time. We've overshot time. Thank you very much. Yeah.
So, judges, would you like the participating teams to wrap up their judgments in the conclusion round, or is this okay?
So if the other judges are okay, we'd like to give everybody just 30 seconds and not more to pass your judgment, a final judgment on each of the parties. See, you have 7 issues which can actually be brought down to 4. So just 30 seconds to give your judgment, exact the relief that you're going to give to any one of the parties.
So do I have the permission to commence with the conclusion segment? Okay, so after careful considerations and deliberations, I hereby conclude that the High Court of Dildar is well within the scope to entertain the present suit, even though the general law related to jurisdiction is being deviated as 3-test doctrine is being fulfilled. And also in the present suit, the conflict of jurisdiction, despite having a foreign entity, would not be an impediment, and the court will still be able to entertain Google LLC being made a party. According to me, on the third issue, the 2017 amendments are violative of ethical TRIPS obligations because they violate Article 3 and Article 4 of the TRIPS agreement, and they do not provide, they put immense powers in the hands of registrar who can go corrupt or who can be arbitrary. On the fourth issue, I feel that the plaintiff is right in saying that the use of their meta tags and adverbs by Koshish Web Services would amount to an act of unfair trade practice and would amount to passing off. Adopting a domain name by Koshish Web Services, which is similar to that of Kanak Web Services, would also amount to passing off in the digital space. And Kanak Web Services can claim well-known status in the Republic of Ethical based on their transborder reputation and the evidence of advertisements that they have given. And on the 7th issue, I hold that both Google LLC and Google Ethical cannot escape liability for the trademark infringement taking place on their platforms, as they're not mere intermediaries, but they're rather direct beneficiaries. And by this, I conclude. It was a pleasure to be here. Thank you.
I'd like to conclude my opinion in the judgment. Firstly, the court has jurisdiction to entertain the present matter under section 20B and 20C of CPC. Secondly, the foreign litigant is allowed to be tried within the jurisdiction of this Dildar High Court. Thirdly, the court cannot adjudicate on the validity of a law in this present commercial suit. Next, Koshish Web Services is liable for passing off for using KWS as meta tags, keywords, and in their domain name. Second, next, plaintiff can claim well-known status based on transborder reputation, but not on prior registration. Lastly, Google is liable. Google Ectel and Google LLC both are liable for being a contributory, as it has allowed use of keywords which are identical or similar to marks of others. Therefore, I think the defendant number 1 should be permanently injuncted from using the domain name kws.koshish.co.ae and the wordmark KWS in any form in their business or selling, offering, etc. Next is that the defendant number 2 and 3 are directed to remove all advertisements from its server browser website, which will amount to trademark infringement or passing off. And lastly, the defendant number 2 and 3 shall restrain the advertisers from further use of third-party trademarks as keywords in their Google AdWords program. That was my conclusion in the judgment. Thank you.
If I have the permission, may I begin? I'll now like to present a conclusion in a very short and brief format. After careful consideration of the arguments of both the plaintiff and the defendants, I find no hesitation in entertaining this case based on internet or web presence of the parties, decisively making explicit departure from the general law as to territorial jurisdiction, based on the precedent mentioned in the regarding as far as issue 2 goes, based on the precedents which are mentioned and the guidelines that I have cited. I have cited 3 guidelines for the applicable standards as to foreign litigants. As far as the third judgment goes, the 2017 impugned amendments, I do not find them to be violative of ITCA's TRIPS obligations or discriminatory. May I please have 30 seconds to conclude? The use of meta tags and adwords similar or identical to someone else's proprietary marks to yield better search results does amount to an act of unfair trade practice by Koshish Web Services. Koshish Web Services is liable for the offense of passing off as they unfairly tried to associate with Kanak Web Services. The transborder reputation is a ground for claiming well-known status, while prior registration of a word mark is not. And Google Ethical and Google LLC cannot be held liable for allowing keywords which are identical or similar to the proprietary marks of others. It was a pleasure being here. Thank you.
So now do we move on to the judge's chamber to discuss?
Yes, so if you'd like, we could shift you all into the judges' chambers for a discussion, and you all can then proceed with installments. Does that work?
Yes.
All right. So, as I'll just do this.
Ma'am, you can just click on breakout rooms and you would have the option to move to judges' chambers.
Congratulations, participants. We will just wait for the judges.